Welcome to the first installment of A Prosecutor's Perspective. My name is John Fleming and I'm a prosecutor in the Nacogdoches County Attorney's Office. This program is intended to provide information to the public about the duties and responsibilities of the County Attorney's Office, including general discussions of criminal law that this office prosecutes. We hope through this effort that the viewing public will learn more about its prosecuting attorneys, what they think and what they do, and we hope that this program will enhance the public's understanding of the role of a prosecutor in local law enforcement circles. This public venue allows for more detailed discussions of what happens in a prosecutor's office. It allows for more detailed conversations and hopefully a more complete understanding of the nature of prosecution. It is our hope that we can introduce various partners, colleagues, and counterparts to the community who work closely with prosecutors, whether it be peace officers, probation officers, advocates who assist victims of crime, those in education, those in the medical community, the defense bar, or mental health providers. We hope we can be a voice to help educate the public on the role of prosecutors. None of the opinions expressed in the show are intended to replace or be legal advice. You should consult an attorney of your choosing if you have or think you have a legal problem. Joining us today is Stephanie Stevens. Stephanie Stevens is a prosecutor in the Nacogdoches County Attorney's Office, started her prosecuting career in Harris County 20 years ago or more, and then left to go to Waller County where she prosecuted additional years and is now in Nacogdoches County. She's a veteran of the courtroom and has tried over 200 cases to a jury verdict, including Stephanie, capital murder cases. Welcome to the show, Stephanie.
Thanks, John. I'm really excited to be here today and to get an opportunity to talk to the general public about what we do at the County Attorney's Office. You know, most people's perception of what happens in a prosecuting attorney's office is formed by things they see on television. And you see reality shows, and you see news shows, and you see dramas and comedies, and none of that is actual real life. Actually, it's probably a lot more entertaining than what we do every day.
Of course, yes.
But our primary job in the county attorney's office is prosecuting crimes.
Right.
So I'm really anxious for us to be able to talk to the public about that and try to educate people a little bit. And anytime we're talking about misdemeanor crimes, especially in a college town like Nacogdoches, then the first thing that comes to your mind are DWIs, or driving while intoxicated.
Yes.
And John, as you're aware, we filed somewhere around 4,000 misdemeanor cases last year, and I think probably 400 of those were driving while intoxicated charges.
Yes, that's correct, Stephanie. In the county attorney's office, we prosecute only misdemeanor cases, but one of the most significant crimes that we prosecute are DWI cases, and we probably did have approximately 400 DWI cases that were presented to our office in 2014, and probably a similar number in 2013. It's definitely an issue probably for all communities, but it can be an issue for a college town in particular, where we have young people who are experimenting more, who are away from home for the first time, and we certainly want to take that into consideration when we're developing strategies to prosecute DWI.
Sure, and John, we talk about DWI, and you hear people talk about DWI and DUI sometimes. People mix those up a little bit. First of all, what is DWI? What is driving while intoxicated?
Sure. Well, driving while intoxicated is a Class B misdemeanor in the state of Texas. It can be a Class A misdemeanor. But really DWI, which stands for driving while intoxicated, is much more than that. There's elements to all crimes that prosecutors present to a judge or to a jury. And in the case of DWI, it's actually operating a motor vehicle in a public place while intoxicated.
as the result of the introduction of alcohol, a controlled substance, a dangerous drug, or a combination of those intoxicants into someone's system.
And you said operating, and I think what's real important about that is that the title itself is driving.
Sure.
So a lot of people have the perception that you've got to be driving down the roadway to be guilty of DWI, but that's not true.
That's correct, Stephanie, and I think that's a misunderstanding that is common, and a misunderstanding that certainly I had but before I entered the legal profession. But it's operating a motor vehicle in a public place while intoxicated. And operating can be as simple as having the engine of the vehicle on. In other words, the engine is engaged and a foot on the brake. That can be operating a motor vehicle. The vehicle doesn't have to be moving. If the car is on, that can be considered operating and therefore driving while intoxicated.
So I know that I've seen a lot of cases where somebody has maybe passed out at a red light.
Sure.
And they're sitting there with their foot on the brake and the car's in drive, but they're not moving. And a lot of times people will say, but I wasn't driving. But under the law, they were still operating, right?
Exactly, Stephanie, and that's one of the points we'd like to make through a forum or a venue such as this, that the definition of DWI is much broader than what people think, because some people will say, well, I was just in my vehicle. Well, if the vehicle was on, you can be considered operating that motor vehicle and therefore violating the law if you, in fact, were intoxicated.
And John, when you talk about motor vehicles, I think it bears a little bit of mention that we're not just talking cars here, we're talking any type of motor vehicle. Four-wheelers are something that people forget. You're out having a good time on the four-wheeler and you're driving through a parking lot or some other public place and you've been drinking to the point that you're intoxicated. It doesn't matter that that's not a car, that that's a four-wheeler. It's still driving while intoxicated.
Absolutely. Or it could be a boat, for example.
Absolutely.
Our office works closely with the game wardens, in particular around holidays when people are accessing the lakes and the rivers and whatnot, boating while intoxicated.
And John, recently we've even had a flying while intoxicated, operating an aircraft.
Yeah.
Is also, while intoxicated, is also a DWI.
Yes, there is. There's a pending case of flying while intoxicated in our office right now. That case is slowly working its way through the system. But Stephanie, I did want to follow up on one point. You mentioned a few moments ago the difference between DUI and DWI, and I know that you've actually had more experience in that subject than I have. What is your understanding of the difference between DWI and DUI?
In Texas, John, DUI, or driving under the influence, is an offense that a minor can be guilty of because there's a certain standard. You have to be intoxicated to be charged with DWI or to be guilty of DWI. But DUI just means having any alcohol on board. And anyone under the age of 21 who's operating a motor vehicle while they have had any alcohol in their system is guilty of DUI. And it's a Class C misdemeanor. It's not something somebody goes to jail for. It's a fine offense. But it's still a very serious offense that can follow a young person for a lot of their life.
Now, that is not to say that a person who is younger than 21 could not be charged with DWI. Is that correct?
Oh, absolutely not. But there's a lower standard for this other offense. You know, there's no law in Texas against drinking and driving. Probably better practice is not to take the risks, but a person can have a glass of wine or a drink or a beer and drive a motor vehicle if you're 21. But if you're younger than 21, that's not an option for you because it's not legal for you to drink at all.
Exactly. You mentioned a few moments ago, Stephanie, operating a motor vehicle as one of the elements in a case. Let's talk about public place for a moment.
Sure.
What is public place? What does that mean in connection with the DWI prosecution?
A public place is basically any place that a substantial part of the public has access to. Probably what we see most common are other than roadways, of course, that are public places, is a parking lot someplace. Sometimes it's a parking lot leaving a club or a bar, sometimes just someone cutting through a parking lot. We occasionally see people who are going through the drive-through of a fast food restaurant and they're intoxicated. And even though they're not on a roadway, they're still in a public place, so they're still, assuming they're intoxicated, guilty of driving while intoxicated.
And I think it's worth noting that many of the employees who work in some of the restaurants where there's drive-throughs have been very helpful to law enforcement in terms of providing notice to police officers or deputies or troopers that there may be an intoxicated person who is using the drive-through. Is that correct?
Absolutely. I mean, you have to remember those people are going to have to get on those same roadways to drive home. And the whole purpose behind our laws against driving while intoxicated is public safety. So, you know, we're not trying to punish people for having a good time, and our legislature wasn't trying to do that when they made this a crime. Our legislature is trying to protect everybody who's sharing these roadways and public places, and that includes the people working at the drive-through.
And would you agree with me, Stephanie, that and you've tried multiple DWI cases over your career, is that correct?
That's correct.
And in those cases, it's typically not the element of operation of a motor vehicle or public place that is what's being disputed.
No.
Why are most of our DWI cases that go to trial going to trial?
You're seldom in court arguing over whether or not a person was in a public place or not. The majority of the time you're arguing over whether or not a person was intoxicated.
Yes.
And interestingly enough, in Texas, intoxication is defined by 3 alternative methods. You can be intoxicated because you've lost the normal use of your mental faculties, because you've lost the normal use of your physical faculties, or because you have a breath or blood alcohol concentration of 0.08 or greater.
What does that mean, to have an alcohol concentration in your blood of 0.08 or greater?
It means that, and John, you know I'm going to get all the milliliters per liter confused and backwards, but it means that a sample of your blood has been taken, that a certified lab has tested that sample and determined that the ratio of alcohol in your blood is to a point that our legislature says there's an assumption out here that you are intoxicated. We called it a presumption, but we're going to presume that you're intoxicated because your blood alcohol level was 0.08 or greater.
And I've heard some people describe this as if we had a 12-ounce beer here, and a person of average size drank 5 12-ounce beers over the course of 1 hour, they very likely would be at a 0.08. In other words, counting that 12-ounce drink as 0.02, and we multiply it times 5 beers, that would put us at about a 0.10. We would probably be, correct me if you think I'm wrong, at a 0.08 with that fictitious person, because he or she would be metabolizing some of that alcohol. Is that correct?
That's a real rough estimate, and I don't want people to be relying on that. That is the standard estimate that people use. But I think it's real important to keep in mind that that's affected by body size. It's affected by individual metabolism. It can be affected by how much food you have in your stomach. Are you drinking on an empty stomach? Have you eaten a big meal? All of those are important factors. So yes, it's a very safe estimate, but it is just an estimate. I would hate for someone to be relying on that. And I also think it's important, John, for us to talk about the other 2 definitions, loss of normal use of mental or physical faculties, because a person could actually have a breath or blood alcohol concentration of less than 0.08, but still be intoxicated because they've lost the normal use of mental or physical faculties.
Absolutely, and I think probably what you're talking about, Stephanie, are what I like to think of as the Bettys of the world. The Bettys of the world who are inexperienced drinkers, who haven't had a lot of alcohol consumption in their lifetime, and they take 1 drink of a beer and they become impaired. either physically or mentally. And they take that one beer, that 12-ounce beer, they drink it, and their blood alcohol level may only be at a .02. So they are not intoxicated by our first definition of .08, but if they are impaired, either have poor judgment or slurred speech or their balance is poor, they very well may trigger one of the other definitions. Would you agree with that?
I would, because when we talk about the loss of the normal use, what we basically mean is you're not normal. You're not at your best, because we want people who are operating heavy machinery like motor vehicles to be at their best when they're in public places. And you may have somebody who has no tolerance for alcohol. And you may have somebody who's been drinking for years, but they just don't have a tolerance, and they are very quickly affected by alcohol, because alcohol is an intoxicant.
So if we only had one definition of intoxication, that definition being .08, it wouldn't protect the public from the inexperienced drinker.
Absolutely, and we want to protect the public from everybody. You know, with an experienced drinker, you may have someone who, because they drink all the time, or just because they mask the symptoms fairly well, they can maintain. They can drive that 4 blocks from the bar home. They do it every Saturday night. They can do that. We're not worried about them getting on the road and going 4 blocks under the same conditions they have every time they do it. What we're worried about is the time that the car pulls out in front of them. Because even though they appear to be masking symptoms of intoxication, they could well have still lost the normal use of their mental or physical faculties. So that seeing the person, remembering this is where I put the brakes on, this is where I turn the steering wheel, that reaction time is slowed. So even though a person appears to be maintaining, they still may have lost the normal use of their mental or physical faculties. That's the reason it's important to have that .08 definition also, to cover that person who can mask some of the physical or mental symptoms, but not those actual reactions that are so important when you're driving.
And I think a couple of things on that point, and we're talking about in that situation where we have an individual who might appear to be sober, but something seems wrong. Something doesn't seem right.
Exactly.
And I think we've both heard of this red ball example. Can you kind of describe that?
Sure. You know, when you're driving down the street and a red ball rolls out in front of you down the roadway, what do you think's coming next, John?
A child.
A child, obviously. You know, that happened to me recently. I was driving down the street and a ball came rolling out of a yard and across the street, and I slammed on my brakes. And luckily, in this case, there was no child coming. And also, of course, I had not been drinking when I was doing it, so my reaction time was what it should be. But, you know, what if I hadn't been able to stop like that? What if I had had a couple of drinks? And alcohol is a central nervous system depressant. It slows things down. So what if my reaction time, that might be a fraction of a second when I'm normal, was slowed to 1 or 2 seconds? That might be just the amount of time that child needs to get out. You know, it may not be a child. There may be an animal running across the street. There may be an adult who just didn't see traffic coming, and they walk out into the street.
And what we want a person to be able to do under those circumstances is connect the fact that there is a ball that has come out into the street with a child. Make that connection mentally.
Absolutely.
We don't want the mental faculty to be impaired such that one looks at the ball but does not connect it to a child who has probably bounced the ball out into the road or is going to be chasing the ball or something like that. In terms of a physical faculty in that particular scenario, we want to make sure that someone can pick their foot up off of the accelerator and safely and precisely put it back down on the brake versus putting it back down on the accelerator.
Absolutely. John, I don't know about you, but when I was first learning to drive and I was driving a standard, there were a couple of times where something happened suddenly and I thought I was going for the clutch, but instead I slammed on the brakes. Imagine that situation if you'd had a couple of drinks. You know, we talk about, I said a couple of drinks, and that brings to my mind that we hear quite often, but I just had a couple of drinks. And I like to think of a hypothetical situation. You know, suppose you're putting your kids on the school bus in the morning and the bus driver tells you, hey, I just had a couple of drinks. Or suppose you're getting on an airplane.
Yes.
And the flight attendant comes on and says, we're going to be taking off in just a minute. As soon as the pilot gets here from the cocktail lounge, he's just had a couple of drinks.
Right.
I don't know about you, but I'm not putting my child on that school bus, and I'm not staying on that airplane.
Right.
And the reason is because we understand that it may just take a couple of drinks. You may be okay at 2, but you may not be.
Right.
And the safer thing is always don't assume the risk. Don't get out there and try it.
And we'll move from this subject in just a moment, but I've also heard it like this, Stephanie, is that you can have a child who is sick and throwing up or something like that, and the mom or the aunt takes the temperature of the child, and the child's temperature is 98.6 degrees. Is the child still sick? Absolutely.
Sure.
Absolutely. Or we can have it the other way, where the child's temperature is 103 degrees but isn't throwing up, doesn't necessarily look sick but has a fever and obviously is. So we can have an individual who might not look intoxicated but who is in fact intoxicated, and that's how I think of it with the .08. Another reason that we have the 3 definitions is to protect the public from what I sometimes think of as the victors of the world, those who take too much Vicodin, if that's what they happen to be prescribed. If we only had one definition of intoxication, and that was intoxication by alcohol, then it wouldn't protect the public from the individuals who take too much of the prescription pills or take prescription pills that they're not supposed to and then get behind the wheel of the car. As I've had communications with some of our peace officers in the community, they've indicated that there's been a spike in the number of pill cases, as they call some of the DWI cases.
Sure, John. And you know, as we've been talking, I've been talking about drinks and alcohol, and that's probably because that's the most common intoxicant we see. But actually, our law provides that if you're intoxicated by any means, by alcohol, by a controlled substance, by a drug, whether legal or illegal, or by any combination of those things. You know, sometimes we see people who are charged with driving while intoxicated, and they say, but I was just taking my prescription medication.
Yes.
Well, a lot of prescription medication, if you'll read those pill bottles and you'll read those admonishments the pharmacist gives you, tells you don't drive, don't operate heavy machines.
Yes.
Sometimes it's just more important to take your medication and stay put or have somebody else drive you and not be driving yourself, where you put yourself and other people in danger.
Absolutely. And on this subject of DWI, so often times we hear people say, well, I'm not going to provide a breath specimen or a blood specimen upon request when they have been arrested for suspicion of driving while intoxicated. What does that mean, to refuse to provide a breath or blood specimen?
Well, first of all, Texas is what's called an implied consent state, which means that when you are issued a driver's license, because driving is a privilege, not a right, when the state of Texas gives you a driver's license, you are implicitly agreeing that you will consent to having a breath or blood sample taken. Now, that doesn't mean you can't refuse. There may be some consequences. Your driver's license may be suspended. There may be other consequences there, but you can refuse. If that situation happens, what law enforcement can do is get a search warrant, because our courts have ruled that drawing blood from somebody is a search. So what the peace officer does is prepare an affidavit laying out his probable cause, why he believes that you might be intoxicated and why he believes he needs a sample of your blood. He presents this to a judge. The judge reads it, and if he agrees with the peace officer, he signs the search warrant, and then someone draws their blood. Here in Nacogdoches, we have a great cooperative system. We have judges who try to remain accessible to law enforcement. We have a local hospital that not only provides courtesy blood draws, but has actually allowed us to set up a computer and a fax machine so the officers can communicate with the judge. And once the officers have that search warrant, you really can't refuse at that point. I mean, that search warrant says they can hold you down and draw blood if that's what they want to do. And John, an interesting thing here in Nacogdoches County is we've become a no-refusal county. Kind of tell us about that.
Yes, in Nacogdoches County, we're a 24/7, around-the-clock no-refusal county, meaning that our no-refusal weekends are no refusal throughout the year. We hear about no refusal weekends or no refusal holidays, but in Nacogdoches County, through cooperation with local law enforcement, Stephanie, we've been able to make it such that at any time of the day or night that someone is placed under arrest for DWI and refuses to provide a breath or a blood specimen, an officer, a peace officer, may request a blood search warrant from a local judge. Now, the judge would review that search warrant and determine, or review rather, the affidavit and determine whether or not a search warrant should in fact be issued. It's been very helpful to our community in my view. Years ago, the control of the investigation of the crime scene, and we have to remember that a DWI is a crime scene. There's a tendency to forget that because some think of DWI as a victimless crime. I happen to disagree with that. But having said that, when the suspect was able to refuse, and they still can refuse, but when they refused and the officers were not able to collect a blood specimen, it put control over the criminal investigation into the hands of the suspect. Now we have peace officers who control and dictate how far the investigation can and will go. There are times that a judge is not available. There's time when there's other pressing calls or there's staffing issues. And when we have that, we sometimes don't have access to the blood. But overall, we have a breath or a blood specimen on probably over 90 to 95% of our DWI cases, which it doesn't necessarily increase the conviction rate because, as you know, Stephanie, and this is a subject for another day, but a prosecutor's responsibility is to seek justice, not a conviction. But what it does do is allows us to know how intoxicated an individual was. Do we need to be equipping that individual, requiring that individual to have an ignition interlock device or an in-home alcohol monitoring device, which we can discuss at another time. But in short, an ignition interlock device would prohibit someone from being able to start their car in the event that they were intoxicated. But in any event, we think that it's been a successful initiative. We've had it in place probably now for about 5 years or so. And it gives the prosecutor and I think law enforcement a better handle on what we're up against. And what we learned through this process is that many who refuse to provide that breath specimen have a very high alcohol concentration, sometimes as much as 1.5, 2 times. Stephanie, I see that we're running out of time. Do you have any last thoughts?
John, I just think that it's probably really important for people to remember how serious this offense is. That you know, we all know somebody who's probably driven when they shouldn't. It's one of those crimes that's committed by just your average person. You know, people we know, people who are friends,
Yes.
may have one of these in their background.
Yes.
It makes it a little bit more difficult to talk about.
It does.
But it is important, and it's something that I hope we've been able to shed a little light on today.
Well, thank you, Stephanie, for your time. I look forward to seeing you again.
Look forward to being back again.